Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 186. I hope everyone's been keeping safe and out of harm's way. As usual this episode, no, it's not usual this episode. We don't have 3 cases. In fact, we don't have any cases at all. But don't worry, this isn't another forensic analysis of coronavirus guidance notes that probably didn't deserve the attention it was getting. I did want to talk a bit about the job support scheme that had been announced and the ACAS CBI TUC joint statement on handling redundancies. Given that, according to ACAS, something like 37% of employers are contemplating making redundancies in the next 3 months, and I'll make you a bet that the true number is much higher than that, I thought it would be interesting to discuss the job support scheme and the joint announcement in the context really of what does this mean for employers who are looking or considering making redundancies in these times. I thought I'd then tie that in with some personal observations on redundancies and handling them sensibly. So, as I say, a slightly different approach to the podcast today, but nonetheless, I hope an informative one. Don't forget, the podcast, as always, is available. It's on iTunes, Mayer Brown website, YouTube, Twitter, Spotify, Google Play, Yahoo, etc., etc. And Twitter is where we post out the links to cases when we have cases. But we won't need to do that this time, will we? So, loosely under the title Redundancies in the Time of COVID. Well, looking at the news over the last week, a number of things really struck me. There's a widespread expectation that autumn, winter, and indeed I think into 2021 will see a significant number of job losses. The furlough scheme is winding up at the end of this month, with the Brexit uncertainties to add on top of everything else. Well, one of the features of the British economy has been the comparative ease with which staff can be made redundant, certainly in comparison with many European jurisdictions. Employment tribunals are often very reluctant to get into the weeds on the business case for a redundancy. You may think that's understandable, management have to be respected, or you may think that if employment tribunals can evaluate things such as unconscious discrimination, unconscious bias, they can evaluate or agree the strength of a business case for making a redundancy. Nonetheless, the law is clear and employment tribunals are relatively hands-off the substantive reason for the redundancy. So, and again talking generally, employment tribunal scrutiny of redundancies is focused primarily on the procedural aspects of the redundancy, and only a relatively cursory glance is given to the business case for reducing headcount. Against that background, therefore, we've got 2 potentially significant developments. First of all, we have the ACAS CBI TUC joint statement on handling redundancies, which was issued on 24th September 2020. I struggle to think of another occasion when there was a similar joint statement on this topic. But what does it say and what's its impact likely to be? Well, the statement recognises that times are tough and as a last resort, employers may have to make redundancies. The statement then goes on to make a number of very sensible and possibly relatively uncontroversial statements. For example, it says that redundancies should be a last resort. Alternatives to redundancy often emerge through effective consultation with workers and trade unions. The statement calls on all employers considering redundancies to work with trade unions and employees and follow 5 key principles. Redundancies, it says, should be done openly, thoroughly, genuinely, fairly, and with dignity. In connection with the principle of doing redundancies openly, the statement says there are rules for collective redundancies, but whatever the scale, the sooner people understand the situation, the better for everyone. Unquote. The statement says that doing redundancies genuinely means being open to alternatives from individuals and or unions and feeding back on those suggestions. By itself, the joint statement has no direct legal effect. It is a call to action rather than having a legislative effect. But it's difficult to disagree with a single word in that statement. And I wonder whether we'll see some employment tribunals hearing submissions, the redundancies done after the statement, was issued, which were not done openly or thoroughly, should be found to be unfair, because this joint statement represents the norm for reasonable employers. I do not think by itself it will lead to tribunals delving more into the business case for making redundancies, but I do think it will encourage a level of procedural scrutiny. Well, what about the job support scheme? Well, this comes into force on 1 November and runs for 6 months. It coincides with the ending of the furlough scheme. At this stage, we only have the fact sheet. We do not yet have the equivalent of the Treasury notice that we eventually had for the furlough scheme. So I can confidently predict that there will be more developments in the job support scheme between now and the end of the legislative process. However, based on what we know now, the question is whether this will have any impact on employers looking at redundancies. In order to answer that, it's probably necessary to start with what we know about the job support scheme and then step back and say how will it affect redundancies. Well, first of all, in order to be covered by the scheme, broadly speaking, an employee must work at least 1/3 of their normal working hours. The employer and the government then each pay 1/3 of the unworked hours. So, if the employee is working at the lowest level, the employee is then working 33% of their time, and the employee's unworked hours are 67% of their time. 1/3 of those unworked hours is 22% of the time. So the government pays 22%. On top of that, the employer pays 22% for those unworked hours, and the employee then waives the rest of their pay. As we'll see, it's not quite that simple, but that's the actual idea. Now, the percentages for the contributions reduce the more the employee is actually working. So, to take another example, if the employee is working 50% of their time, the government and the employer each contribute 17%. Note, however, for the employers, national insurance and pension contributions are payable by the employer on top of the payment to the employee. It's not clear at the moment whether the employer tops up the national insurance contributions and pension contributions on all the unworked hours, or whether that is simply unworked hours paid by the employer. Obviously, the existence of social security costs on top of the supplement for unworked hours pushes the costs up potentially significantly for the employer. There's a cap. The maximum amount the government can be required to contribute is £697.92 per month. I think this means, if my maths is right, that an employee with a monthly salary in excess of £3,169 gross, that will leave the employer proportionately more out of pocket. Next thing to bear in mind is that the scheme does not apply to all employers equally. In particular, for large employers, category is yet undefined, there is to be a financial assessment test. It will be necessary for that type of employer to show that their turnover is lower than before they experienced the difficulties with COVID. So it looks as if the test is in two parts. Is the turnover lower? And is it partly caused, contributed to by COVID? There's no such test for small and medium-sized enterprises. Now, this echoes one of the themes from the furlough scheme, where the issue was whether the employer needed to show that it had been adversely affected by the pandemic in order to be able to furlough employees. Secondly, and then again an issue that we encountered a lot with furlough, and particularly with American clients who were particularly concerned about this point, there is the guidance note says that there's an expectation that large employers will not make capital distributions while they're accessing the grant. And that could potentially preclude dividend payments or share buybacks. This restriction would not apply to medium and small businesses. Now, it's an understandable view given the understandable disquiet about public money being paid to companies that in turn were handing out money to their shareholders through dividends, for example. But I wonder whether this requirement will be used by large employers to justify making redundancies rather than making use of the job support scheme. I suspect that employers who refuse to pay out dividends in compliance with this requirement might find their share prices punished as a result, which of course causes other financial difficulties for the employer. There's then a very odd sentence in the fact sheet which leaps out at you when you read it. The fact sheet provides, quote, "Our expectation is that employers cannot top up their employees' wages above the 2/3 contribution to hours not worked at their own expense," unquote. Now, if you think about it, that is a quite magnificently ambiguous statement. Are they saying that in order to claim under the scheme, employers must be unable to afford the full amount of the salary? If so, how's that going to be measured? Are they saying that employees going into the scheme should not have their wages topped up, even if the employer could afford to do it? In that case, what's their thinking? So I'm afraid I simply don't understand what is going on here, although doubtless the government will provide some clarification before the 1st of November. In another throwback to the furlough scheme, the fact sheet addresses the issue of employee consent to being on the job support scheme. The fact sheet says that employers, quote, must agree the new short-term working arrangements with their staff, unquote, stop. The employment contract must be amended by agreement, and they must notify the employee in writing. Again, this seems to suggest that in some cases employers may already have the power to make the changes, and so agreement may not be a matter of altering the contract. It may already be implicit in the contract. But for many employers, they're going to need employee consent to waive the balance of the salary, bearing in mind that without appropriate consent, the inaction by the employee doesn't authorise the deduction from salary. And that remains a live issue through until the reduced salary is restored in full. Interestingly, it looks as if employees are going to be notified directly by HMRC that they're in the scheme to prevent employers presumably being able to fraudulently claim and keep employees working throughout. So the first question is, what is the existence of this scheme going to do to the likely standard response by British employers to reduce headcount, to adjust costs, to get them through the coming economic hard times? Well, I think the scheme is going to be something that employers are going to need to consider, but I think it's going to fall a long way short of being a block to many redundancies. For example, what happens if the employer simply doesn't have enough work for an employee to do 33% of their time? We all know industry sectors, entertainment, live music, etc., stuff close to my heart, is poleaxed at the moment. There isn't 33% work to be done by the workforce. However you cut it, is the employer just going to pay that extra cost, which will of course be irrecoverable, and ask the employee to do a lesser percentage of work? What's going to happen in areas where there are local or indeed national lockdowns and people can't work? Next up, some benefits are indivisible, irrespective of whether the employee is working part-time or their normal working hours. Think of a medical expenses policy, for example. The cost of that doesn't alter if the employee works 33% of their time. So it's a real issue, as if those costs won't reduce, then the costs of keeping an employee on are disproportionately higher if the individual is only working 33 or 50% of the time, whatever. Even where benefits can be prorated, we don't know at this point if benefits are going to have to be provided in respect of unworked hours as a condition of membership of the scheme, or can the employee waive those divisible benefits in respect of unworked hours? What's going to happen to employees who are sick and absent by reason of illness? Will the employer be expected to cover their full wages? So, again, it's a broad comment. The greater the costs the employer is expected to bear for employment hours that are unworked, the less likely they are to embrace this scheme. The problem in particular is that if the job could continue to exist, employers have a choice. They can negotiate directly with the employee to reduce the hours to whatever percentage is feasible for the employer, and then the employer effectively offers the employee a choice: accept the revised hours or leave. Employees with less than 2 years continuous service have very little economic bargaining power in many cases. And this could be a much cheaper option for an employer in most cases than claiming support under the job support scheme. It also sidesteps the restrictions brought about by being in the scheme if you're a large employer. Secondly, I think it's likely that employers who believe that redundancies are going to have to come will not want to defer them because of the costs they will still have to bear and the scheme restrictions whilst the employer is making use of the scheme. Even allowing for the fact that a severance payment will often come with notice pay, statutory redundancy, and then some sort of markup on top of it. It may still be cheaper for employers to make redundancies now rather than to keep individuals on the job support scheme and see what turns up in 6 months' time. In some cases, employers may reason it is better to terminate contracts now and then hire people next year when the worst of this has passed, hopefully. Some of the weaknesses in the UK scheme can be seen from a comparison with the German equivalent scheme. The German scheme, which has been around for a while, applies in similar circumstances and usually applies for a 12-month period, but this has already been extended until the end of 2021 in Germany. Employers receive up to 60% of the pay for hours not worked, and that also takes care of social security payments. So compared with a maximum 22% payment and no social security cover for the UK, the difference is pretty stark. Indeed, in order to access the 22% grant, the employer has got to be paying 22% out of its own pocket to the employee plus social security costs. So putting all that together, where does the job support scheme take employers? Imagine an employer who's looking to make redundancies and wants to know now whether the job support scheme is something they have to sign up to, or does it radically alter the risk profile for the redundancies they want to make? Well, the first point, I think, is that an employer who makes redundancies without even considering whether the job support scheme would provide a valid alternative is asking for trouble. The scheme is there as a support for viable jobs, according to the fact sheet. It is a source of government finance for employers. Going back to the joint statement, employers need to be open to alternatives, which I think clearly means engaging with the scheme in principle. And if it is not the solution to the employer's proposals, the employer needs to volunteer an explanation why. In that context, I wonder whether the requirements by employers to pay significantly more than the hours worked by the employee in question is going to limit the attractiveness of the scheme. An employer that is in financial difficulties, or is saying that the job is not a viable one for the future, or it doesn't have confidence it's a viable one for the future, would seem to have a clear-cut reason for preferring the redundancy route, the job support scheme route. I mentioned the unattractive nature of the restrictions too for larger employers. So I think, although the job support scheme might offer a glimmer of hope to those who think employers should be quizzed by tribunals more closely on the rationale for redundancies, i.e. the substantive reasoning rather than merely the procedural steps, I think it is something that employers are going to be able to sidestep, provided they are seen to consider it. It's going to become a procedural matter rather than a substantive one. And I think we will see a lot of employers point to the fact the scheme is overtly says it is designed to support jobs that are viable in the longer term, rather than, in my terms, so-called zombie jobs. Therefore, the rationale for not applying to the scheme will be that the employer does not believe the jobs are viable longer term. By the way, none of this is to suggest the job support scheme is a bad idea or that employers will never use it. I just don't think it's going to stop redundancies, and it's not going to preclude employers who want to make redundancies making those redundancies pretty low-risk fashion. Well, putting that all together, where does that leave redundancies in the time of coronavirus? Coming all the way back to our original question. Well, it's pretty easy to have a clear idea about the sort of process, the redundancy process should be followed. The technical steps for making redundancies are well known, and the requirements don't directly change as a result either of the joint announcement or the job support scheme. So, imagining myself the hypothetical question of the top bits of advice I'd be giving to employers looking to make redundancies in the next 3 or 6 months, and frankly some of it is looking to make redundancies at any point in the future, I think my advice would be the following. 1. Recognise the audience who will judge you for your redundancies. Ultimately, the lawyers who bring claims representing individuals who've been dismissed will never be impressed by what you've done. A tribunal will decide what it does 12, 18 months down the line. The real audience is, of course, the people you are making redundant and how they feel about things. But indeed, probably of greater importance is the workforce that is going to remain with you after the redundancy exercise. My experience is that a workforce that see redundancies handled in a sympathetic way and, broadly, which agree with the decisions which are made as to who stays and who goes, will remain on side. A workforce who thinks the management does not know what it's doing, or worse still, does not care about the impact, will lose faith and trust in that management if they see the redundancy exercise being messed up. So, making sure that the remainers are looked after, as well as rather than just focusing on the leavers, is important, and where we've heard that before. Secondly, think about the timing of the redundancy exercise. In my career, I've had to explain to a number of employers why starting a redundancy exercise 2 weeks before Christmas is a thoroughly bad idea. Whilst it's unlikely that an employer would ever lose a tribunal case merely on the basis they've started a redundancy exercise 2 weeks before Christmas, you're certainly making life much harder for yourself in any contested hearings if you've been sufficiently unwary to start redundancy exercises then. There is a debate about whether it's better to start redundancy exercises at the start of December to let people know jobs are at risk so that they can moderate Christmas expenditure, or hold them over until January. That's a different debate, but I think in practice, if you've not announced redundancies by the start of December, there would need to be a very good reason for announcing them during December. Remember the audience of remainers who are watching you. Thirdly, training of managers who are going to handle redundancies is essential. No one should feel good about having to walk into a meeting and deliver the news to someone that they are at risk of redundancy. And in those circumstances, managers often find that the stress really affects how they approach things. There's one story from Mayor Brown's dim and distant past of a redundancy exercise where the manager, the partner, told the associate they were being made redundant, but couldn't actually bring themselves to say the words, "you were being made redundant." So the associate left the meeting utterly ignorant of what had actually gone on in the meeting, and HR had to follow up with them to explain that that was in fact a redundancy consultation meeting. The advice I give to managers is to be straight about the redundancy proposal. Don't beat around the bush. However, it's absolutely fine to be sympathetic, provided you're not disagreeing with the proposal. There is sometimes advice that issued, managers must be just robotic and deliver the message and then get out. I think a degree of human interaction is to be expected, and a surprising number of employees respond positively to a sympathetic message with the bad news. Next up, encourage managers to listen during consultation, whether it's collective consultation or individually, and indeed particularly in relation to individual consultation. I've done a number of redundancy exercises where, relatively late in the day, often at an appeal stage, an employee says to the manager chairing the appeal meeting, this is the first time anyone has actually listened to what I'm saying about this redundancy exercise. And look, that's clearly a failure of management to get to that point, but it does show the importance of listening, evaluating what the employee is saying, even if it's hopelessly wrong or it's obviously flawed. Conversely, employers should be prepared to alter proposals where good points are raised. No one has a monopoly on good points, and so the employer should be willing to compromise during consultation where it's appropriate to do so. I think there's very little danger in an employer saying during the consultation exercise the employee or the union or representative has thought of a point that has not occurred to them. In the light of that, there's going to be an adaptation of the approach, or there's going to be an alteration to the marks or something of that nature. If the consultation process is working, the employer's processes and decisions will be adapted as a result, and they'll be stronger. The redundancy proposals are not a ditch to die in, a piece of land to be fought over every piece of the way. In some cases, points made will be fair ones. Next up, remind managers that it's extremely easy for employees to record meetings. This is even more the case where you have Zoom meetings or other WebEx whatevers. It may not be apparent to the manager that the meeting is being recorded. Similarly, it may not be apparent to the manager there is someone else in a room with an employee if it's a Zoom call or something like that. And the employee may be getting prompted or having notes passed to them about what to say and points to make. Managers need to understand they should assume at all times everything they say in those meetings will be on the record. It does no harm at the start of an exercise, particularly if you do have the opportunity to brief management who are going to be involved in the redundancy exercise, to emphasise to them the need to avoid sending unfortunate emails. Management, in my experience, rarely appreciates the difference between a redundancy proposal and a redundancy decision, and their preparatory emails usually read as decisions taken, not proposals being considered. I lost a redundancy exercise case many years ago because the senior manager involved, when kicking off the planning for the redundancy exercise, had sent an email to his direct reports, which they'd immediately responded to, entitled, "Let me have your list of deadwood." Ho-hum. Next, penultimately, I think employers formulating redundancy proposals should now address as standard why the job support scheme is not the answer, to demonstrate they've considered it and evaluate it. I think it's a compulsory subject for consultation, both at collective and individual level, for an employee to challenge why there is a redundancy exercise when government support is available. And employers need to be patient and clear in dealing with that. And as I say, I would lead with it so that people don't think you're ducking the challenge. Finally, I also think employers should use the CBI ACAS TUC joint statement as a bit of a checklist. Are they able to answer yes to the principles enunciated in that statement if they're asked whether or not they've complied with them? I think that would be very important. So I'm sure there are many other practical points that people bear in mind when they're handling redundancies. I'd be very interested to hear if anyone wants to suggest any additional learning points, and I'll put them out in the next podcast. I'm doing a talk for the Employment Lawyers Association in one of their training talks in a few weeks' time on the subject of individual redundancy. So, to be honest, any practical stories or thoughts would be gratefully received. Anyway, thanks very much for listening. I do hope that was useful. In the meantime, please stay safe, keep out of harm's way, and I confirm that we have received no money from the Job Support Scheme for the making of this podcast. Bye all.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.